So they said, what is the supreme law of the land? It's the Constitution. The laws made by Congress in compliance thereto, and all treaties made which shall be made under the authority of the United States. It did not say the rulings of the Supreme Court. And the reason it did not say the rulings of the Supreme Court is that's interpretation of Constitution and application of the facts. Historically, the Supreme Court could rule adversely to the Constitution, can't they? In 1857, they held black people to be property.
They did.
In the case of Dred Scott.
But as you know, they came back and reversed, and that was the law of the land at the time. They ruled it, and they stayed property. Later, they came back and reversed. They may come back at some time.
They didn't come back in reverse, Chuck. They had the battlefields of the Civil War
Reversed.
and a constitutional amendment. And that was quoted, by the way, in Roberts' commentary in the dissent. I don't know if you noticed that, but in Roberts' comment in the dissent, he said this. He said that there was, let's see, I think it's a very important thing. He talked about Dred Scott. Dred Scott's holding was overruled on the battlefields of the Civil War, he said. Here it is. Dred Scott holding was on page 12 of the opinion. If you want to see it right here, let me show it to you. Now, I think what I'm doing here is very explicit because I want to make sure that I stick with agreeing with Supreme Court justices. I think that's very important. And you notice he quoted Dred Scott there, and he said that Dred Scott's holding was overruled on the battlefields of the Civil War and by constitutional amendment after Appomattox. So basically it took a Civil War and a constitutional amendment to correct the problem the Supreme Court caused. And what the Supreme Court did in Dred Scott is exactly what they're doing today in this court.
Judge, is it going to take a civil war?
I hope not.
In a battlefield.
I hope not. We don't promote civil conflict, and I'm not trying to inspire any such thing. I'm quoting a Supreme Court justice that said that's what it took to overcome the slavery issue. The law of the land is the United States Constitution. Judges are to interpret that Constitution. When they interpret that Constitution, it is according to their oath to the Constitution. If they interpret it as Justice Kennedy does, it allows for same-sex marriage.
Right.
If they interpret it according to Justice Scalia and Justice Roberts, Justice Alito, and Justice, which one did I get? Thomas. Then it contradicts the Constitution. I agree with Justice Scalia, Roberts, Thomas, and Alito.
Sir,
I think
that equals 4 votes.
that equals
There
4
were
votes.
5 votes. Those 4 votes don't count now.
That's first.
The
And,
5 votes count.
and that sets a precedent for the lower courts. I agree. But I can't agree that it is the Constitution because, as Justice Roberts, Scalia, Thomas, and Alito said, it contradicts the Constitution. Has nothing to do with the Constitution. The court's decision today, according to Thomas, is at odds not only with the Constitution, but with the principles upon which this nation was built.
You're very eloquent and passionate about this, but can you at some point accept a decision by a majority of the Supreme Court that says this is the law? This is not unconstitutional, and gay people.
I can interpret it as it's meant to be. Courts can't make law.
Is your answer that you can't accept?
Courts cannot make law. Do you agree to that? Do you think courts make law?
I think courts change history, and sometimes for the better, and sometimes
You're right, they do
and
change
sometimes
history.
for the worse.
Do you think courts make law?
I think
If you do,
5 members of the Supreme Court make a majority, and when they make a decision,
it does not become a law.
No,
It
it does
becomes
not.
a precedent.
It becomes a precedent,
Right.
and it is a precedent, sir, that is almost universally followed.
Except, that's right, I agree with that. I agree with your comments and your statement. They make a precedent which is to be followed by the lower courts. But the law remains the Constitution. And I have a right as a judge to interpret the Constitution just like every judge does. I can dissent, just like Scalia, Roberts, Alito, and Thomas. And I will dissent, because a court can't make you think that same-sex marriage is in the Constitution when it's not. They can't make you think it's a fundamental right